A very good afternoon, everyone. I am Disha Dugar, a practicing CS by profession and founder at Corporate Advisors Law Professionals, also known as CALP. Now, as you all know, we are in the third phase of the countrywide lockdown, and in these odd 44 days, our businesses have faced a slowdown or have come to a standstill. Now, in order to cope with these difficult times, the finance minister has announced several relief measures relating to statutory and regulatory compliances across sectors in view of the COVID-19 outbreak. Now, we shall be discussing the initiatives by the Ministry of Corporate Affairs, which is the regulatory body for all companies and LLPs in India. Now, this is a technical session, so I suggest you keep a pen and paper handy to take notes of what's applicable for your company or in case you're a professional for your client's company. Now, in between these technicalities, I shall be giving out tips that you must consider as a corporate restructuring tool to make use of the benefits given by the MCA. Now, we shall touch upon very three important reliefs given by the MCA. The first will be the Insolvency and Bankruptcy Code. The second will be on CSR, Corporate Social Responsibility. And the third will be the CFSS scheme, which is the Company Fresh Start Scheme. Now, thereafter, we shall delve into the regular working of the company reliefs, and in the end, we shall share with you some important announcements for your companies as per the COVID-19 outbreak. Now, let's start with the Insolvency and Bankruptcy Code. Now, the IBC is a code wherein a creditor can file a time bound insolvency petition at the NCLT against a corporate debtor if the debtor has defaulted in the repayment of dues, which is an amount exceeding 1 lakh rupees. So, this is what the IBC code states. Now, due to the emerging financial distress faced by most companies on account of the large scale economic distress caused by the COVID-19, the Government of India has come out with a circular which is applicable from 24th March 2020. Please note 24th March 2020. From this date, the threshold of the default has been increased from 1 lakh rupees to 1 crore rupees. Yes. So, if you are a corporate debtor, you shall gain from this circular and the vice versa for a creditor. So, this will by and large prevent the triggering of the insolvency proceedings against the medium and small scale industries. This basically, in a layman's language, means say you are a corporate debtor, your company is a corporate debtor, and you have defaulted in repayment of dues which exceeds 1 crore rupees. That is when a creditor can pull you to the NCLT to file an insolvency petition. That means they can liquidate your company if the repayment or the dues are more than 1 crores. Now, I will share a few examples which will make it clear as to how and when this can be triggered. Now, suppose X is a private limited company and it has committed a default in the repayment of a loan of, say, 1.5 crore rupees from a bank Y. Now, there is another financial creditor, say Z, who owes 95 lakh rupees from the company. Now, this 95 lakh rupees is not yet defaulted. And so the question is, can this other person Z who owes 95 rupees from the company can file an application against the company in NCLT? The answer is yes. Now, why is this so? Because in this case, the company has a total default which is exceeding 1 crore. So, which is why even if there is another financial creditor who has a default amount which is less than 1 crore, he or she can file an insolvency petition against this company at the NCLT. Now, I'll give you another example. Say it's the same company X. Now, in this case, the default amount from the bank Y is 45 lakh rupees. That is the total default from the bank Y is 45 lakh rupees. There is another financial creditor which has a default of, say, 75 lakh rupees. Now, can this other creditor, Y, who has a default of 75 lakh rupees, file a case against the company? The answer, and out of this 75 lakhs, say the default amount is 50. So the actual default by the company is 45 lakhs from the first bank Y and 50 lakhs from the second financial creditor. So the total default is 95 lakh rupees, which is why the other financial creditor cannot file a suit. Now, this is so to understand this better, let me tell you the definition of aggregate financial debt. So, if all the financial creditors of the company have a total amount of debt which is more than 1 crore rupees, any of the financial creditor can file a suit against the company. And that is not the case if there are operational creditors in the company. Now, I will explain this further with another example for operational creditor. Now, say X is the same company, it has three operational creditors M, N, and O. Now, M has a due of 30 lakhs, N has a due of 1.1 crore, and O has a due of 95 lakhs. Yes, so 30 lakhs, 1.1 crore, and 95 lakhs. Now, which of these individual who is an operational creditor can file a suit against the company X? Now, here the answer is that only one operational creditor, that is Mr. M, can file a suit. Now, why is this so? Now, so in as per for financial creditors, there is no provision of aggregating debt owed by their operational creditors. Hence, it is necessary that the threshold under the IBC is met individually by the operational creditor. So, which is why if an operational creditor individually has debt more than 1 crore, that is when he can file a suit against the company X. Now, also, as you all know, due to the COVID, the courts and the NCLTs are shut right now. Only urgent matters are being taken care of. Now, as per the NCLT notice, the IBC 2006 matters of extension of time, approval of resolution plan, and liquidation will not be construed as urgent matters. So these matters will be taken up as soon as the regular bench starts working. Until such time, you cannot make an application under the IBC code. So what we conclude from this is that if you are an operational debtor, you will benefit from this change of the default limit. And if in case you're a creditor and you have dues of say 10 lakh, 20 lakh, 50 lakh, or even 90 lakh, and you're an operational creditor of the company, you cannot file a suit against the debtor. Now, the second important relief that we'll discuss is the corporate social responsibility. Now, CSR is applicable to companies who have a net profit of 5 crores or more, or if the turnover is 1,000 crores or more, or if the net worth is 500 crores or more. So, the company, if it hits the criteria in every financial year, it has to take out 2% of the average net profits of the company, which is made during the three immediate financial years, and spend it on CSR activities. Now, the question in COVID arises whether the spending of CSR funds for COVID-19 related activities shall qualify as CSR expenditure or no. Now, the good news is that yes, it will qualify as CSR expenditure. Now, the ministry has via a circular dated 23rd March 2020 clarified that yes, the funds used for CSR for COVID-19 activities shall qualify as CSR. It is under item number 1 of Schedule 7, which relates to promotion of healthcare, including preventive healthcare and sanitation and disaster management. So, COVID 19 comes under the Disaster Management Act. Now, there were a lot of questions which our clients had come up, where the contribution will be considered as CSR and where it not be considered. So we've jotted down a few points. So if you make a contribution to the PM Cares Fund, it shall qualify as CSR expenditure. Now, there are several funds at state level also for the disaster management. Now, these shall not qualify as CSR expenditure. For example, contribution made to Chief Minister's Relief Fund. This shall not qualify as a CSR expenditure. Or if you're making a contribution to the State Relief Fund for COVID-19, it's specifically for COVID-19, even then it will not qualify as CSR expenditure. Whereas there is this one specific authority at the state level, if you make contributions there, it will qualify as a CSR expenditure, and that is the State Disaster Management Authority. Yes, please note down, it's the State Disaster Management Authority to combat COVID-19. It shall qualify as a CSR expenditure. Now, as you all know, a lot of companies as employers you have cut down the salary of your employees, staff, daily wage workers. Now, a lot of people asked us if we are paying a full time salary or wage to an employee or worker, including contract laborers, during the lockdown period, shall it be adjusted against the CSR expenditure of the companies? Now, the answer to this is no. The reason being that payment of a salary or a wage in a normal circumstance is a contractual and statutory obligation of the company. Similarly, if you're paying salary and wages to workers during the lockdown period, it is a moral obligation of the employer, as the employee does not have an alternative source of income. So, which is why this amount shall not qualify as admissible CSR expenditure. Now, there is another exception to this. If you are making an ex gratia payment to temporary casual workers or daily wage workers, which is over and above the disbursement of the wages specifically for the purpose of fighting COVID. So, if there's an ex gratia payment which is over and above the daily wage or the normal disbursement of wages, and it is specifically for fighting COVID 19, that shall qualify as a CSR expenditure. So now, though there is a certain requirement under the Companies Act, if you're making such a payment, you have to first explicitly declare at your board meeting, and then it has to be duly certified by your statutory auditor. That's when it will qualify as a CSR expenditure. Now, let's come to the third most important topic, relief given by the Ministry of Corporate Affairs for companies. Now, this is known as the CFSS scheme, that is the Company Fresh Start Scheme 2020, and the LLP scheme, relief scheme, LLP settlement scheme 2020. Now, what this basically means is that no additional fees shall be charged for any late filing during a moratorium period between 1st April 2020 to 30th September 2020. So, if there are any documents, returns, statements which are required to be filed by your company at the MCS site, which was not done during its due date, you can file them right now with zero penalty and additional fees. Yes. So this is basically to make the long-lasting non-compliant companies and LLPs make a fresh start right now. Now, the applicability of the scheme is for any defaulting company, and they can file belated documents. Now, the good part is under this scheme, the company gets a complete immunity from prosecution and penalty for delay in filing. So there are a lot of forms which are not filed within the due date by companies. There is prosecution and penalty. So prosecution means you can be jailed for it, and the penalty amount is huge, charged by the ministry. Now, both of these have been waived off under the scheme. Yes, so the duration of the scheme is 1st April to 30th September 2020. Now, please note that the scheme is not applicable on a few companies. That is, if your company is struck off, a struck off company cannot avail this benefit. If it's an amalgamated company, if it's a dormant company, or if it's a vanishing company. There are also several forms which are not included in this scheme. For example, or if there's a form of increase in the authorized share capital, if you have missed SH7, you cannot file it under the scheme. Or if there are charge forms, if you have created a charge or a mortgage on your property against a loan from a bank, you have to file a form CFG1. That those forms are not included in this scheme, whether it's CFG1, 4, 8, or 9. So any charge related forms is not included in this scheme. Now, there are a lot of forms which companies usually miss out. Which we've noticed in the these years of practice and consulting our companies. Now, one such form which is very importantly to be filed by a lot of public companies, public limited companies, which are missed by companies, is the form MGT14. Yes, MGT14 is to be filed within 30 days of passing of a board resolution. Now, there are a lot of board resolutions which needs to be filed for MGT14. For example, if a public company has issued securities, or you have borrowed money from a bank or any financial institution, or you've invested the fund of the company, or say you've given a loan or a guarantee. And so this item of financial statement approval by the board is also to be passed via MGT 14 by public companies. So if you have a public company, you have to pass your financial statements every year. So it is compulsory to file an MGT 14 for this by every public company every financial year. Now, other matters are, say, appointment of the internal auditor or secretarial auditor, or if you have appointed a KMP, a key manager, that is CEO, CFO, whole-time director, managing director, CS. That's also when you need to file MGT 14. If you've bought back your shares, or you have diversified the business of your company, or made political contributions, even if you've taken over another company, you need to file this resolution in MGT 14. Now, please note, now this is very important, that all of this was applicable for private companies also from 1st April 2014 to 5th June 2015. Yes. So, government companies, private companies, Nidhi companies, and public companies all were required to file Form MGT 14 for these matters from 2014 April to 5th June 2015, after which an exemption was granted to government companies, private companies, and Nidhi companies from June 2015. So now it's only applicable to public companies. Now there are a lot of other resolutions also which needs to be filed in MGT 14, which companies miss out, public companies. I'll state a few of them. Suppose there is a managerial personnel that you need to appoint who is beyond the age of 70. A special resolution is required and MGT 14 is required. If you've shifted the location of your registered office from one place to the another, or if you've changed the name of your company, or a lot of times companies just issue shares, private placement issue is made between the issuers and the company, but the same is not filed at the ROC. So in that case, if you suppose you're giving a loan to your managing director or whole-time director, or say if you want to wind up your company, so in all these cases a special resolution is required and MGT 14 has to be filed. Now the now this is not just the end. You just can't file the MGT 14 under the scheme. There is a procedure to be followed if you have delayed in filing MGT 14 beyond 300 days. The normal filing time period is 30 days. If you've exceeded 300 days, you have to first file to the ministry in a form called CG1. Yes, a CG1 is an application to the central government which gets approved by the ministry. You get an order and then you file the order in a form called INC 28. After getting the SRN of INC 28 approval, then you file the MGT 14. So this procedure is not removed under the scheme. What is actually removed is the penalty amount of MGT 14. If you have not filed for a lot of years, it comes to a big amount. Yeah. Now, there is another important tip that I would like to share with the companies. So mergers and acquisitions are emerging as the new survival tactic for a lot of companies. Because there are a lot of startup firms and there are a lot of large firms. So you can hit a beneficial deal with them right now in these COVID times. Yeah. Now, I'll just point out very quickly a few other forms which are very important, which are usually missed by companies. If you can note it down, it will be really good for you. There's a form called ADT1, which is for appointment of auditors, which is to be filed within 15 days of the appointment, which a lot of companies miss out. They think it's the auditor's responsibility, but it's not, it's your responsibility. Then there is this form DIR 12, which is usually filed for appointment or change in designation or cessation of a director. Now, what is missed by company is, if you have appointed a director as an additional director in the board meeting, the term of that director expires in the annual general meeting. So at the annual general meeting, you have to regularize that director from an additional director to a director. So 90% of the companies and professionals miss this out. They just appoint them as an additional director and leave it to that. But no, at the AGM, you have to file another DIR 12 to regularize the director from additional to a regular. So if you miss that, this is the time to file it. Now, there was this new form which had come out called DPT3, which was applicable to every company other than a government company. It was a one-time and a half-yearly outstanding. If there was any outstanding money or loan in the company, as on 31st March 19, you had to file this form, DPT3. So from 1st April 14 to 2019 March end, if there are any outstanding, this form was to be filed by 30th June 2019. So if you miss that, this is the time to file it. there was this other form for called DPT-4. That means if you had any deposits existing as on first April 2014, you had to file this form. Now, another form which is usually missed by companies is CRA2. This form is for appointment of the cost auditor of the company. Yes, so there is a form for this called CRA2. Now, there are a lot of companies which have dividends lying in their accounts which were not claimed by the shareholders. These get transferred to the IEPF. So, any IEPF form pending can be filed under this scheme. There was this another new form called Ben form, which was basically to find out who the actual beneficial owner of the company is. So, for example, you have a company X, and there are two shareholders in the company who are again body corporates, companies. Now, so in order to find out who the actual owner is, we had to reach to the point where we hit an individual who is the actual significant beneficial owner of the company. So, if you have missed this form, this is the right time to file it. Now, there was this other new requirement called DIR3 KYC. Yes, so if you are a director in a company or a partner in an LLP, it is mandatory to file a KYC in this form. Now, the penalty for this form was quite huge. The penalty was 5,000 per KYC if you missed it. Now, that 5,000 has been completely removed. So now you can file DIR3 KYC without this additional penalty. Another such form for companies was INC 22A. So every company, whether it's a public or a private limited company, is supposed to file this form INC 22A. It was a tagging form where the latitude and longitude of the registered office is given with a photograph of the director sitting in the office. This was a compulsory form, and the additional fees for this form is 10,000 rupees. Yes, 10,000 rupees for one form. So this additional amount has also been removed. So if you missed filing INC 22A, this is the right time to file it. Now, a lot of companies, as I previously discussed, used to issue shares without any professionals' help, and they thought that just issuing shares, giving the certificates, was the end of it. But no, you have to file a form PAS3 as a return of allotment to the ministry within 30 days of issue of shares. So, if there are shares issued to any shareholder, a form has to be filed called PAS3. If this has been missed, you will not get this opportunity again. Please file it now. Now, a lot of listed public companies, who are listed on stock exchanges, usually are concerned with the SEBI filings. They are not, they think there's no additional form to be filed at the ROC. There is this one form called MGT 15, which has to be filed by these companies within 30 days of the annual general meeting. Yes, MGT 15 is for every listed public company. Now, another form which is important, which a lot of you do not know about, is called AOC 5. Yes, AOC 5 is basically when you do not maintain your books of accounts at your registered office. That's as per the act, you need to maintain it there. If you do not maintain it there, if you maintain it at some other office, corporate office, you need to file this form AOC 5. Now, this was for the companies. Now, for LLPs, also there are two forms, which are usually missed out by the companies. Yeah, and the additional fees is rupees 100 per day. Yes, the additional fees is counted as 100 per day. So, if you have missed out, for a few years, or say 4 to 5 years, the penalty can be in lakhs. Now, this form is called LLP 3. This is to be filed just after incorporation of the LLP. So, a lot of times, what happens once your LLP is incorporated, you've got the certificate of incorporation, you feel that you do not need to file any other form. But this is the form you need to file. This is called LLP 3, or with the partnership agreement. Now, the crux is, if later on in the future, if you missed LLP 3, you want to file another form where you've changed a partner, or if there is any change in the LLP, you cannot file a form unless you have filed this LLP 3. So then again, the additional amount comes in. So if you missed LLP 3, this is the time. Also, another form for LLPs which is usually missed is, if there is a change in a partner, or say, email ID of a partner, address of a partner, contribution by a partner, you have to file a form LLP 4. Yes, for any such small changes, this form has to be filed LLP 4. So this is the time to file it. Now, the catch here is, once you file these forms during this period, this moratorium period, Later on, you have to file this form called CFSS e-form. Yes, that will be filed. That will be available from 1st October 2020 to 31st March 2021. So right now you file the pending forms. Then you have to put in the details of the forms filed under this scheme in this form, CFSS e-form. Now, a lot of people have asked me that, my company is struck off, but I want to use this scheme. I have a lot of years of pending filings. So, the solution to this is you first revive your company from the NCLT. Yes, the revival is done via NCLT. And once the company is revived at the registrar, you can use this scheme. This is basically, to utilize your corporate scrap, as they call it. If there's a dead company, bring it to life and then use this scheme. So these were the three important reliefs. Now let's come to your day-to-day company reliefs given by the ministry. Now there's a requirement under the Companies Act to hold board meetings every 120 days. That means the gap between two board meetings cannot be beyond 120 days as per the Companies Act. Now, under the COVID scenario, you have been provided an extension of 60 days. So now from 20 days, it has been increased to 180 days. Yes. And this relaxation is for the next 2 quarters, that is up to September. So you don't have to hurry up and hold a meeting now. You have an extended time period of 180 days. Now, also a lot of matters which require approval, they require the physical presence of directors under Section 173(2). Now, there are these restricted matters which cannot be done virtually as per the Companies Act. Some of them are, if you want to approve the annual financial statements, it cannot be done virtually, or approve the board's report, or if, there are audit committee meetings for approval of the financials, these cannot be done via video conferencing as per the Act. Now, what has happened is these matters are also being removed from this restricted list for a time period of 19th March 2020 to 30th June 2020. Yes, so if you want to conduct any of these matters via video conferencing or other audiovisual means in a board meeting, it can be done during this period from 19th March to 30th June 2020. Now, though, in case you want to conduct a board meeting virtually, there are a few, criteria that you need to fulfill. Now, these criteria are mentioned in Rule 3. Rule 3 of the company's meetings of boards and its powers rules. Rule 3 of the company's meetings of boards and its power rules. Do look it up, 2014. I'll state a few of the items mentioned here. The chairperson of the meeting and the company secretary, if there is any, are responsible for making sure that all the reasonable care is taken for the equipment, for the audiovisual equipment. So there is a two-way communication in the meeting, and the transcript is recorded, and the meetings are prepared where it is mentioned that it has been done via video conferencing, and to store or the safekeeping of this recording is the responsibility of the chairperson of the meeting and the CS. Now, a lot of board members, if there are any differently abled board members, what you can do is you can make a request to the board to allow another person to accompany him during such video, audiovisual, meetings. That is allowed under this rule. Now, another very important relaxation given by the ministry is that CARO 2020 has been extended from financial year 1920 to 2021. Now, what is CARO 2020? Now, CARO 2020 is basically, it's a company's auditor report order, wherein the statutory auditor is required to give additional reporting on a lot of heads under the financials. Now, this is applicable to, bigger companies, not smaller companies. So if CARO is applicable to you, there is a new CARO 2020 which has been extended to 2021. So now you have, so basically what happens in CARO 2021 is there are 21 heads of reporting. There are things like unrecorded income, non-cash dealings with directors, cash losses, or compliance in respect to loan to directors, fraud and whistleblower complaints. All these are usually not recorded in your statutory auditor report, but under CARO the auditor has to report these, and in a very detailed manner. So the reporting is required not only on part of the auditors but also on part of the management, as they have to give the information to the auditors. So there's a lot of compliance burden. So this has been shifted for another year to avoid the burden during the COVID times. Now, there are a lot of companies, as per Para 7 of Schedule 4 of the Companies Act, where the independent directors are required to hold one meeting in every financial year. Yes. So, if you have independent directors, you have to hold one meeting in every financial year where only the independent directors hold the meeting without attendance of the non-independent directors. Now, so for this financial year 1920, this has been waived off by the ministry, and it shall not be considered as a non-compliance. Now, another so this there is another relief for startups. It's called there is a declaration that you have to be filed once you create a new company, which is it's a declaration for commencement of business. Yeah, so if you have a newly incorporated company, within 180 days, you have to, that is 6 months, you have to file this form for declaration for commencement of business. Now, this 180 days has been extended to another 180 days. So, 360 days is the time frame now that you get to file this commencement of business declaration, because a lot of companies will not be able to start their business right now. There is another requirement under the Companies Act where every company in India is required to have at least one director who has to stay 182 days in India as a residency in India of 182 days. If that is not meant it's a non-compliance. Now this has been done away with for the financial year 1920. So even if no director is here for at least 182 days, it's not a non-compliance. Now, the another thing that I would like to share is that the first casualty during any recession is the liquidity of the company, and in order to maintain the liquidity of your company, you will need to defer your reserves, your deposits, and your investment requirement. So the ministry has come out with a circular where if you have deposits or debentures maturing in financial year 2021, you were required to create a reserve by 30th April, 20% and 50% of it. But that has been extended to 30th June. So, you have more liquid in hand for the company. Now, another very important provision that has come up is that now you can hold the AGM and EGMs virtually. Yes. So before we deal into that, also if there are companies whose financial year were ended in 31st December, they were supposed to hold their AGM by June. So that has been extended to 30th September. So even if your financial year is ending by 31st December 19, your AGM can be held by 30th September. Now, AGM and EGMs can now be held virtually. This has just come out on 5th May 2020. There was a circular which said that during the calendar year 2020, an AGM can be held by audiovisual or other audiovisual means. Now you have to note that both ordinary businesses and if there are special businesses which are considered unavoidable can be taken care in these meetings. There are a few criterias. For example, companies. There are two kinds of companies: companies which require e-voting facility and companies which do not require to give e-voting facilities to its members. Now, suppose your company requires e-voting facility to be given to your members, you have to publish, in one vernacular and one English newspaper about the details of this audio-visual meeting. Also, there are other, requirements as per a circular for EGM, which you can find on the MCA side. Now, suppose your company is a private limited company and it does not require e-voting facility. In that case, what you require is that the company should have the email IDs of 75% of the shareholding. Yes, you need to have the email IDs of 75% of. That's only when you can use this audiovisual means for AGM. Now, if a company cannot, apply any of these above procedures, they should just apply to the ROC for extension of the AGM. Under Section 96, that provision is also there. Now, as for the EGM, you can hold it on or before June 30th, if it is considered unavoidable, and you have to follow the same rules as above, and it can be held through video conferencing or other audiovisual means. Now, in case it's a public company, you shall also record the transcript and you shall make it available on the website of the company at the earliest. Another important extension given by the NCA was 20 days of extension for names reserved. So if you had a new company, to be incorporated and the name was reserved, and it was expiring between 15th March to 3rd May, you are getting an extended 20 days, till 23rd May. Or suppose there was a form which had come for resubmission, between this 15th March and 3rd May, you're getting an additional 15 days time for resubmission of the forms. Now, these were the Ministry of Corporate Affairs reliefs. Now, there are two important Ministry of Home Affairs guidelines which have come out, which are very important for every company, which I would like to share. So now, medical insurance has been made mandatory for workers. Yes. So the Ministry of Home Affairs had come out with these guidelines for a standard operating procedure (SOP), which was to be followed by organizations once the lockdown ends and they resume work. Under this SOP, the government has mandated that you have to provide medical insurance to your employees. Now, I will discuss this in detail quickly. Now, the IRDAI, that is the Insurance Regulatory and Development Authority of India, has come out with this circular where it states that all industrial and commercial establishments, workplaces, offices, etc. So this includes industrial, commercial establishments, workplaces, offices, etc. shall put in place arrangements for the implementation of that SOP, and as per clause 5 of Annexure 2, for social distancing, establish medical insurance for the workers to be made mandatory. So the IRDA has made it clear that you need medical insurance. Now, a lot of people have asked me that, what if you are already covered under the ESI, the Employee State Insurance? Now, as per the labor law, medical insurance is available under the ESI uh, to those sectors, to those employees which have a monthly wage below 21,000 rupees. So, say you have you have your employees covered under ESI and their payments is less than 21,000 rupees. In that case, you need not get an insurance done. Now, if there are employees which have a salary of more than 21,000 rupees, in that case, and it is not covered under the ESI, you have to get a insurance policy. So what is suggested by a lot of insurance companies is that you take a group insurance policy for all your employees, and in case suppose they already have their own retail insurance policies, medical insurance, you need not take it. Or if they want to take another retail insurance personally, you might just assist them and tell them how to go about it. So the thing is that if in case they do not have a medical insurance, the employer is responsible for the same. Now, another important, announcement by the Ministry of Home Affairs was that Arogya Setu app has been mandatory by the government. So, what is this app? This app is basically, an Indian government app which has to be downloaded by all Indian citizens, but it is made mandatory for government and private sector employees, and as well as residents of containment zones. Yes, so if you are a government employee or you are a private sector employee, you have to compulsorily download this app. Now, so the Disaster Management Act, under which this and other lockdown rules have been issued, has a provision for jail for violation. Yes. Now, the government has said that the app is designed to keep the user informed in case he or she crosses path with any person who is tested positive. That is the purpose of this app, because there are a lot of questions that are asked in the app when you download it, like what are your symptoms, are you feverish, cough and cold, so you have to answer them, and the data is sent to the government of whoever is downloading the app. Now, but the app has a lot of loopholes too, and the user privacy might be at stake. But then this is a mandatory requirement by the government, so please make sure you download this app. So I hope I have covered whatever was possible and feasible during these 40 minutes. And if there are any queries on whatever I have discussed with you all, you can mail me at disha@calp.co.in, or to our general team at info@calp.co.in. So if there are any future queries, or if you need help on any of the matters, please feel free to mail us. Thank you, and I hope you got some insight into the matters.